case to come before the court is the Summer County, it's Robert Schutte versus the Summer County Sheriff's Office. We have read the briefs and ready to proceed when you are. The appellant may reserve up to 5 minutes for rebuttal. If you are, the appellant wish to reserve that time, let me know and I'll put that time and let me know what the time is.
Would ask to reserve 5 minutes. May it please the court opposing counsel, Donald Gallick on behalf of plaintiff appellant Robert Schutte. We're here today on 2 assignments of error that are interrelated. We have summary judgment that was granted. Obviously, it's a de novo review. There's several, I don't want to say, procedural questions before the court. One is this a wrongful termination case? And I know that the appellee suggests that it isn't because he was working as a special deputy. I find the case law to be relatively scarce on that issue, but I assert that he had a property interest, he had income that he derived from this special deputy status, and that we are certain that it was taken away due to improper and illegal means, as well as not in compliance with administrative law under Title III. Now, because of the journal entry granting summary judgment, as the court knows, it was very scarce. It didn't really give any findings of fact. Now, again, it's a de novo review, but we proffered, into the record many depositions and discovery documents suggesting that there were, at a minimum, issues of fact that a jury could decide that would sustain selective prosecution, wrongful termination, abusive process, things of this nature. The court saw the deposition of David Hillis talking about the money that could be earned from special duty, and also there was depositions that were put into the record about how the discretion was used. They tried to say that we had Mr. Schutte, who was prosecuted at some point in Barberton Municipal Court, although those charges were eventually dismissed and not refiled, so that would certainly show a wrongful prosecution claim. They can refile those misdemeanor charges now if they wanted to, because the statute of limitations would have expired. It also is that he spent $8,000 in legal fees to defend himself against those charges. That's damages that would be recoverable under that one cause of action.
Mr. Gallo, can I back up to the first one?
Please.
Are you suggesting that merely by the fact that that criminal charge was dismissed, it's wrongful prosecution?
It isn't, but I think that there's an element that you have to have, I believe it's either a not guilty verdict, or if you're convicted, then that ends that claim.
So you're saying it's one of the elements?
It's one of the elements. He wasn't convicted, and he's not going to be convicted on that claim. It's legally impossible now. It might not have been when the suit was initiated. I don't have the timeline in front of me, but certainly as we sit here today, he has not been recharged in that case and isn't going to be. And of course, that charge was illegal gravel use or excavations or some quirky third-degree misdemeanor in Barberton Municipal Court. So there's also depositions about all of the meetings that were going on between the elected county sheriff, between the lieutenant, the deputy DeSabato, talking about what to do, what can they do about Robert Schutte, and making this decision to revoke his special duty status. Their testimony sort of contradicts itself. First, it's because of the claim in Barberton Municipal Court. No, it's because of prior incidents. It's not real clear why they did this. These are issues that a jury should hear. The jury can make the decision of what testimony has more veracity and why he actually was prosecuted and subsequently had his special deputy status revoked. We have a deposition where we're going over the Summit County Sheriff's Policy Manual and whether it even applies to special commission deputies. And Sheriff Berry, his answer was it would depend. Depend on what? Well, it depends on the employee. So maybe this employee, we like it, we'll apply it. Maybe this employee, we won't apply it. Again, that's not a claim that should be disposed of through summary judgment. That should go to a jury, and the jury can decide, was there some improper motive for not applying the policy manual to this special deputy, but we are going to apply it to this other special deputy, and whether or not this Barberton case was a factor in him losing his special deputy status, as well as the initiation of that claim as well, because, again, there's testimony, I keep saying testimony, there's depositions that are in the record that show that really Mr. Schutte didn't violate that he had a letter saying that he could use, I know this is really technical, that he could have number 57 gravel. He used number 57 gravel, but he was charged criminally anyway, even though he had a letter from the city of Greene saying that it was permissible for him to use it. All of these are facts that, at a minimum, should allow the case to proceed to trial. It shouldn't have been disposed of through summary judgment. There's no other questions. I would reserve the balance of my time.
Counsel, I have
Yes.
a question for you. In regard to the summary judgment motions and so forth, the sovereign immunity was argued. I mean, obviously we'll go through the record, but I
Yeah.
was just a little,
I'm sure that immunity was raised by the defendant at some point, but again, the journal entry is very scarce. I don't think there was a finding of immunity. I don't think,
there wasn't
Right.
anything in the journal entry except here are the causes of action and summary judgment is.
right. So I think, I mean, obviously it's de novo review. This court can find immunity even though the trial court did not, but we're not here on an immunity issue as far as I know. Thank you.
May it please the court, my name is Colleen Sims, and I am counsel for the appellees in this matter, the Summit County Sheriff's Office, Sheriff Steve Berry and Deputy Robert DeSabato, who are sued only in their official capacity. They were dismissed individually early on, and that issue is not before the court. Sovereign immunity was raised in the motion for summary judgment. It is also addressed in my brief because only the political subdivision is sued in this matter. And I would agree with the appellate that this court has a de novo view and can look at the facts independently in finding that the named defendants, the remaining defendants, are not liable in looking at the record.
Counsel,
Yes.
you are aware that there's a line of cases from this court that says that when there's not sufficient, not record, but sufficiency in the court's order on a summary judgment motion, that we are a court of appeals, a court of review, and even though it's de novo review, the court can exercise its discretion to send the matter back and say, you need to address these issues for the first time yourself.
Certainly, Your Honor, I would agree that if this court reviews the matter independently but finds that the journal entry may not be as descriptive as this court would like, the matter could be remanded for the trial judge to be more descriptive in his
Because
findings.
obviously, put it on the other way, the trial court could have denied summary judgment, and you would have attempted to appeal on the basis of sovereign immunity, because obviously that's immediately built in order. And then if the court had just said summary judgment denied, you would be in a hard position to make your arguments in front of this court. Because you wouldn't really even know where the court was coming from. You don't even know what to present to the court, because you don't know how the court looked at what reasoning it used at in regard to your summary judgment, in regard to immunity. The court, as a matter of fact, may not even look at your immunity. Because at that point, we wouldn't know.
I would agree with Your Honor. I would have to rely on the briefs submitted by the plaintiff and myself and look at the record.
And then if you didn't agree with our rationale, the only recourse would be to go to the Ohio Supreme Court, and we would be the ones to be looking at maybe your arguments for the first time. I don't know. And that's just a bad position for everybody to be in, for you or for them, either way. Because we are a court, for all intents and purposes, last resort.
I would agree with that. But I think in looking at this record and in looking at the elements the plaintiff is required to prove, I think twofold. The political subdivision is not liable pursuant to the Political Subdivision Tort Liability Act of 2744. And I even went further to argue, even putting aside that, I don't think there's anything in the record to show that Sheriff Steve Berry or Deputy Robert DeSabato acted with an ulterior motive to support the malicious prosecution. With respect to selective enforcement, which I don't think there is a lot of case law, but he certainly was not discriminated based on a protected class. He makes a claim that his property rights were infringed upon. With respect to those two causes of action, I believe Robert Schutte's claims are really against his neighbors in the city of Greene who are not parties to this action. There is nothing in the record that he indicates that Deputy DeSabato did something rude to him, ulterior. The record actually supports the opposite, that he behaved in a professional manner and contacted him when a summons was available or ready to be served upon him. And actually, I believe the record shows that Deputy Robert DeSabato performed his duty in talking to members of Greene who initiated this action, in talking to the neighbors, and in talking to his superiors in light of the fact that the suspect had a special deputy commission. With respect to abusive process, and I would argue the brief, I think the appellant's brief doesn't really argue that there is an abusive process claim, which means there is a valid criminal charge, but that my appellees have abused the process. What is put forth is once the charges were filed, that's handled in Barberton Municipal Court. There is a motion to continue followed by Assistant Prosecutor Holly Reese that's included in my motion for summary judgment that indicates that the parties are working towards a resolution. Assistant Prosecutor Holly Reese and Attorney Barry Ward. There is no evidence of any involvement of the Summit County Sheriff's Office with that criminal case once it proceeds. So I think that the appellant cannot argue that there is anything in the record to support an abusive process claim. With respect to the wrongful termination, I would argue that loss of income, pure loss of income, is still not analogous to an employer-employee relationship. And there are documents attached to my motion for summary judgment which shows he acknowledged time and time again he was not an employee of the Summit County Sheriff's Office. In addition, he failed to produce any evidence to show that he actually lost any income. He puts forth some hypothetical questions by one of the witnesses, Dave Hillis, but he doesn't set forth what income he made, although that was asked in discovery prior to the revocation of his special deputy commission. So in sum, I believe the record indicates that there is no solid evidence, even looking in light favorable to the appellant, that supports any of the charges. And I would argue that perhaps the reason the journal entry is as short as it is because there is no evidence that the appellant can succeed in any of the 4 counts. I would just like to point out a few things if there are no more questions. Attached to my motion for summary judgment is an affidavit of Sheriff Steve Berry, which has the policy attached, which is clearly indicates that Sheriff Berry has the right to revoke a special deputy commission at any time. And I believe in looking at the actions undertaken, there is no evidence that anyone but Robert Schutte took such drastic measures in excavating a road he didn't even own. He has a backhoe there. He is not only just laying number 57 gravel, but he is excavating, which is in clear violation of the city ordinance. And there is no evidence in the record that anyone has ever undertaken a 2-week project to excavate a city road. It appeared that Steve Berry did not feel that Deputy Schutte had temperament to continue being a special deputy. And it appears, I would argue from the record, that he became obsessed with this road to the point where it interfered with his relationship with his neighbors. It interfered with his relationship with the city that he lived in. And his actions create no legal liability on the part of the named defendants, the Summit County Sheriff's Office and Sheriff Barry and Deputy DeSabato in their official capacities.
Counsel, is there something that Mr. Schutte was alleged to have done that went beyond what I will term the permission letter from the city of Green, I believe it was the law director?
Yes, and I believe Deputy DeSabato discusses it in his deposition. They feel he did more than just lay gravel on the road. Is that he was, with this backhoe, he was excavating, he was changing the nature of the road to the point where the city of Green, who's not a party to the suit, contacted the Summit County Sheriff's Office to pursue this misdemeanor of the 3rd degree against him. It was not just the laying of the gravel, which is why he was summoned. It was the massive project that he undertook. Thank you. If there are no other questions, thank you for your time.
Great, I'll have 5 minutes left.
Thank you for that precision. I have to say some of the things that Appley stated might be true, but I don't think all of them are in the record. If they are, I apologize. But I would say there's other litigations that are going on that are not before this court, and we can't really use them in this appeal, I don't believe. I will say this about, talking about is there anything in the record to show any kind of improper motive or abusive process or selective enforcement or anything like this. There is in the record that it took 9 days to make this decision to issue this 3rd degree misdemeanor, and I believe I cited in the brief, we might have had as many as 8 government officials involved deciding whether or not to issue this 3rd degree misdemeanor. The Sheriff Barry, he sees the letter, what Judge Callahan, or I think you said the permission letter, or however you want to claim it. He goes, well, I haven't seen that letter. So you have 8 people making a decision over 9 days, and I didn't see that letter. And then I think in his deposition at some point, it's like, well, had you known that this letter existed, had you known the charges were going to be dismissed, had you known all these other things, well, I still would have made the same decision. I still would have removed his special deputy commission. Well, if the case is the reason that you removed his special deputy commission, and you knew the case was going to be dismissed, and had you, it seems inherently contradictory. The initiation of criminal charges was given as the main reason why his commission was being revoked, but even if you'd known the case wasn't supported by probable cause, wasn't going to be prosecuted, was going to be dismissed, there's a letter saying that maybe he had permission to do this, it wouldn't have affected your decision at all. And I believe in Sheriff Barry deposition, he says, no, it wouldn't have made a difference had I known these things at the time. Again, you put this in front of a jury, what would they say? Taking 8 officials, various law directors, city attorneys, sheriff's departments, in-house counsel, they all get around to issue this 3rd degree misdemeanor over a 9-day period. It's certainly possible a jury might see that as evidence of abusive process or malicious prosecution. If there's no other questions, I would ask the court to thank the court for its time. Thank you.